What happens when someone walks into a criminal courtroom, not as a lawyer, not as the defendant, but claiming to be an attorney of fact? Today, we're breaking down one of the most bizarre courtroom moments you'll ever see, where a man attempts to use a sovereign citizen playbook to derail a criminal trial in Tennessee. We've got a judge who is not having it, a mystery man who may or may not be the defendant himself, and a legal document that the court is about to tear apart in real time. Who is Matthew Aldridge? Who is this self-proclaimed attorney of fact? And can you actually challenge a court's jurisdiction by filing Latin phrases from Black's Law Dictionary? Buckle up, because this one goes off the rails fast.
All right. Good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any.
Okay, let's pause right here, because this is a critical legal distinction that trips people up all the time. An attorney in fact is a real legal concept. It's someone granted authority through a power of attorney document to act on another person's behalf in civil or financial matters. But here's the thing, it has absolutely zero standing in a criminal court proceeding. A criminal defendant must either appear personally or be represented by a licensed attorney at law, full stop. And when the judge asks point blank, do you have a power of attorney document? And the answer is, I do not. Well, that's game over before it even started. Now here's the big question for you watching. Do you think this man is actually Matthew Aldridge trying to dodge his own court appearance? Or is he genuinely someone sent on his behalf? Drop your answer in the comments, because things are about to get even stranger.
Authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me. Apparently there's a copy here. All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the, that's the respondent and heir signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an article pre-trial?
To what?
Will that be an article pre-trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. But I don't know who you are. And I don't think you have any authority, if you are not Matthew Lynn Aldridge, to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this. And I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, General, we're going to need to set a trial date in July.
July 15th.
I'm sorry.
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me, whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore deny whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are, in fact, Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
And that, ladies and gentlemen, is how a sovereign citizen strategy crumbles in a real courtroom. Let's break down exactly what happened and why it matters. Matthew Aldridge failed to personally appear on his scheduled last plea day before a jury trial. A man, who never confirmed his own name on camera, attempted to invoke sovereign citizen legal theory by filing a document challenging the court's standing, citing an 1852 civil canal case and Black's Law Dictionary definitions. The judge correctly identified this as legally irrelevant to criminal proceedings, denied the motion outright, and reset the trial date to July 15th, with a final plea deadline of July 8th. The judge's warning was crystal clear. If Aldridge doesn't show up on July 8th, his bond gets revoked, and he'll be sitting in jail when trial day arrives on the 15th. The sovereign citizen movement has a long history of using tactics like these, but courts across the country have consistently and unanimously rejected these arguments in criminal cases. They simply do not work. You cannot opt out of the criminal justice system with a piece of paper. If you found this case as eye-opening as we did, make sure to hit that like button. Share your thoughts in the comments below. Do you think this man was Matthew Aldridge himself? Well, and don't forget to subscribe for more jaw-dropping courtroom breakdowns delivered straight to your feed.